Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Buying and Selling Home Health and Hospice Agencies. Today's presenters are Heidi, Kocher, and Jennifer Papapanagiotou. Jennifer's practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing businesses arrangements for compliance with federal and state fraud and abuse laws and drafting a wide variety of legal agreements. Ms. Papapanagiotou is also knowledgeable in all aspects of state licensing for home health and hospice providers and in Medicare and Medicaid enrollment, including initial enrollment, changes of ownerships, and appeals of revocation actions. Finally, she has assisted clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. As for Heidi Kocher, she is a partner with the law firm of Laos Parker. She has over 20 years of experience advising and defending healthcare clients on legal and regulatory matters affecting providers of all sizes. She is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a Chief Compliance Officer and Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers up to through the LAJ level. She received her JD from Georgetown University Law Center. She is licensed in Texas and Maryland and admitted to the U.S. Court of Federal Claims. She's also a certified in healthcare compliance. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. You guys will also receive a copy of the PowerPoint tomorrow. So without further ado, I present to your presenters, Jennifer Papapanagiotou and Heidi Kocher.
Thank you, Gio. All right, well,
Jennifer.
we'll go ahead.
Sorry, Heidi, are you going to start? I thought I was going to take the first half.
Oh, I misread the email then. Go ahead. You go ahead.
Sorry about that. Hi, everybody. This is Jennifer Papapanagiotou. Thanks, Gio, for the introduction. And Heidi, feel free to chime in at any point. Let's go ahead and click to our first slide here. So welcome, everybody. Today, we're going to talk a little bit about home health and hospice transactions and try to just kind of fill you in on sort of the latest and greatest trends that we're seeing, and then talk a little bit about transaction basics, sort of the regulatory laws that we worry about the most in transactions, and then cover the basics of how a transaction happens and what kinds of steps and documents are most often developed and executed as part of a transaction, and then a little bit about kind of post-closing issues and just sort of special issues that come up in these very specific types of deals. Because healthcare in general, given how highly regulated it is, and home health and hospice in particular, because they are the subject and target of some very specific limitations or guidelines that we have to follow because of payer issues and licensure issues and whatnot. They have some real sort of special, unique aspects to them. So let's go to the next slide. So what are we seeing out there now when we look at transactions? And I can tell you, having done this for too long to talk about, that we do see trends. And I will say that we had a big upswing in the volume of transactions during COVID. Like the 2019, 2020, 2021 timeframe was extremely busy. A lot of consolidation going on. Larger organizations buying smaller organizations, and money was fairly inexpensive to borrow during that time period, so buyers were able to easily access financing, and it just really drove a lot of activity. We saw a lull as COVID was kind of winding down, and I think there was a period where all those acquisitions that had happened, they were sort of integrating. They were trying to sort of the organizations that had bought up businesses were kind of trying to bring them into the organization. They were building and get things on track. We were seeing some ebb and flow and enforcement going on, with a real upswing in looking at things like pandemic funding programs. You know, all of those obligations to report were happening, and buyers were a little more nervous about how the pandemic related financing programs were going to affect liabilities in sort of the short term and long term basis. So we saw kind of a lull, and at the same time interest rates went up, and it really slowed down the pace of transactions overall. And I remember several deals I was working on in the 2022 timeframe, especially late in 2022, where we, you know, may have even gotten as far as it's a letter of intent and are working on due diligence and maybe even transactional documents, and buyers just came back and said, listen, we can't do the deal right now. The financing is just not, it doesn't work. The numbers don't work anymore. Fortunately, that seems to have changed, and I'm definitely seeing an upswing in activity. I don't know that money's gotten a whole lot cheaper. I do think, you know, there may be some other, some buyers that have built a war chest, frankly, or they've managed to put financing in place and negotiate pricing for acquisitions that's more, that allows them to realize value in a deal. They've reevaluated the metrics, and frankly, they've repriced deals. So we are definitely seeing a lot more transactions. Some things to keep in mind: hospices are seeing some changes in the last regulatory cycle with the final rules that have been released. We saw two things specifically. One, hospices in Arizona, California, Nevada, and Texas that undergo a true change of ownership, or which is an asset sale, or 100% change in equity owners, will be subject to what they call enhanced oversight by the Medicare program. And that enhanced oversight can look like a lot of different things, but ordinarily what it means is you're going to get ADRs and you're going to be audited, maybe not on a large scale basis, but they're going to look at how new ownership is running those organizations and evaluate their compliance. They also extended what we've always referred to as the 36-month rule for home health agencies. That's now been extended to hospices as of January 1, 2024. And what that means is that a hospice cannot have a change in majority ownership or 100% sale of assets more often than every 3 years. And there's some exceptions to that rule, but the purpose of the rule is to try to stop churning of of hospice licenses and Medicare certifications. They want to kind of kill the idea that someone can just go out, get a license, get an agency accredited and certified, and then turn around and sell it and flip it. So they're going to essentially force the issue and say, if you're going to start an agency, you're going to have to hold it for 3 years if you want to sell it. That's been in place for home health for a while, and there are ways you can navigate that as a buyer. If you find that's an issue in a transaction, we deal with that quite a bit. Integrity auditors are still very, very active. We're seeing lots and lots of TPE in hospice. And, you know, home health has sort of always been a target for enforcement activity. And we're seeing, you know, we're still seeing suspensions, we're still seeing revocations. Although I will say, at least in my practice, I'm seeing fewer revocations of home health and hospice agencies unless they've been the target of a number of audits that were very negative, that had very high error rates. The one thing CMS has been very focused on over the last, I'd say, 12 to 24 months is a revocation reason that allows them to kick someone out of the Medicare program if they have repeated really bad audits. And it's called a pattern or practice of billing errors. And while there's kind of an interpretive case law still being developed around that authority and how CMS is using it, there's a list of factors in the regulation. What we're seeing practically is if an agency has 3 audits in a row with very high error rates, they very much run the risk of a revocation action by Medicare. What that means is, obviously, everybody has to manage and respond to audits and denials very proactively. And I'll just leave it at that, but it is something we are seeing more of. I would say 5 years ago, the pricing for agencies focused very much on census, or more on census than it did on other factors. That has largely been replaced by looking at pure financial data, whether that's revenue or EBITDA. I see both, frankly, driving pricing for deals. Really what that means to me is it's not enough just to have a healthy patient census and show you can maintain that census over time. You also need to have good, clean books, and you really need to focus on getting your financials in order and making sure that you are running an efficient business if you want to get maximum value in a transaction. Let's go to the next slide. All right, transaction basics. First and foremost, lots of folks will call me up and tell me they've got a letter of intent and they'd like to close the transaction in 30 days. And the very first conversation we have is sort of to adjust expectations, because transactions, particularly in healthcare, generally are very difficult to do in 30 days. Most transactions, and this is just sort of a trend, it's not a hard and fast rule, we do have regulatory timelines to give notices, and sometimes having to file advance applications in certain types of transactions. If, for example, in asset transactions, you have to apply for a change of ownership license in Texas in advance. So you have applications and materials to submit on a particular timeline. Medicaid has its own guidelines and timelines if you participate in any of the waiver programs where you have a separate contract with the state. So if you either have a hospice contract or if you have like a primary home care contract, those have advance notice and application requirements as well. And that's just the bare bones regulatory timelines you have to meet before you can actually have a transaction close. In addition to that, the parties have to do things like complete due diligence, draft all their transactional documents, and oftentimes there are other consents that have to be acquired for a transaction to be closed and for a change in ownership to actually happen. So one of the first things we do when we're sort of assessing a transaction is talk about timeline and make sure everybody understands this is not going to happen overnight. It really does take optimistically 90 to 120 days, sometimes longer, sometimes shorter, to get things like this done, and done well and done thoroughly. There are a lot of drivers for selling during COVID and the period, during and shortly after COVID. I know a lot of owner operator type companies were just done, they were burnt out, and they were ready to sell and either do something else or retire. And that certainly drove a lot of transactional activity in the 2020 to 2022 timeframe. I will say just the increased complexity of running a healthcare business has definitely driven consolidation, and larger organizations that can bring technology to bear, that can create some efficiencies of scale, and that have resources to keep up with all of the very, very many things any home health or hospice operator has to be skilled at. It takes a team, and it's really hard for small companies to do some of these things without significant support. And often I see, larger companies bringing smaller companies into the fold, and sometimes they retain the ownership or management of those targets that they acquire because they have such great local knowledge and connections that can drive structures of transactions as well. But I will say, it really has been big guys buying up little guys. And the advantages of that are, it gives often capital for growth and consolidation and reduction of expenses and just economies of scale. My third bullet here is nobody, either on the selling or the buying side, should do a transaction involving home health or hospice unless both sides need to have legal counsel. I don't suggest that anybody share attorneys. Buyers and sellers don't have interests that are aligned with each other. And it really, I think it's important for both sides to have independent counsel. I often have sellers come to me and they want to hire me to represent them, and we get to talking, and sometimes it's one small guy buying another small guy, and they're like, well, the buyer doesn't have an attorney, and they're wondering if we could just draft the transactional documents. And I'm like, not really what I would recommend. And let's see if we can't find that buyer good counsel that can help guide them. There are just too many conflicts, and the whole nature of a transaction really is that you're divvying up risk. And as part of the transactional document, you're deciding who's going to be responsible for what liabilities and what are everybody's rights and promises to each other going to be. And it's just unwise for each party not to have their own lawyer. It also is becoming, and has been for years, most deals get done with a team. It's not going to be just a lawyer. It's often going to be a lawyer along with your accountant, maybe a valuation expert if you're on the buyer side, or maybe if you're looking to sell your business, you want to get a good valuation done up front before you take it to market so you kind of know what you're worth. But more and more, and especially on the buyer side, these things are done with a team of people that help with evaluating targets, doing due diligence, doing clinical diligence. So it's rarely a one-man show when it comes to helping a buyer or a seller through a transaction. Let's go to the next slide. Do your homework and don't be afraid to walk away. That's really advice both to buyers and sellers, maybe a little bit more to buyers. Both parties really need to get comfortable with each other. There's a certain amount of trust that parties need to build to do a deal together. And sellers want to be comfortable that the business they're selling is going to somebody who is going to treat the employees well, that's going to treat the patients well and provide good care. And buyers really need to understand what they're buying. They need to know all the good, all the bad, all the nitty-gritty details. And especially if they're not active in a particular market or geographic area, they have to sort of learn your geographic area and how your business functions within that geographic area. So the due diligence phase, which is sort of the homework phase where everybody learns about each other, I can't stress how important it is. It's just a reality that a lot of deals get to the letter of intent stage, and they usually do that with just very little in the way of information other than financials. And just some bare financial data can allow a buyer to develop an offer for your business, which they may document in a letter of intent. An offer all by itself, just based on financial data, is great. But what it really means is, if everything's great, this is what I'll pay you for this business. It's often after you've reached that sort of basic agreement on purchase price, you then move on to the due diligence process, and facts can pop up that give buyers pause. Sometimes things change. It happens. I wouldn't say on a percentage basis, if I had to guess, maybe 20% of deals don't proceed. It could be more, it could be less, but I would say in the deals I've worked on over the last 5 years, that's probably a pretty good estimate. 20 to 25% of them they get to the letter of intent stage and never go any further, really. Or they get into due diligence and for whatever reason, they stop at some point. Every deal is different and is very specific to the buyer and the seller, but they do have a lot of common themes and a lot of common documents and processes. So most deal documents, whether it's an asset transaction or an equity transaction, are about 70 to 80% standard. And they're kind of can be transferred from any industry. So a deal to buy, a gas station will largely 80% look similar to a deal to buy a home health agency, but it's that 20 to 30% that's very specialized that really sets healthcare apart from like lots of other general transactions. And it's why I recommend to people that you don't just need a lawyer, you really need a healthcare transactional lawyer who understands your business. Somebody who buys and sells gas stations is not going to understand the home health business, not going to understand the hospice business. They're not going to know what hospice cap is. They're not going to know what kind of quality data you have to submit. They're not going to know what a cost report is. They're not going to understand the terminology or some of the liabilities and risks associated with these businesses. So in my experience, really important that you don't just have You don't just have transactional counsel, you have healthcare transactional counsel. Let's go to the next slide. All right, important steps and documents. In every deal, there's kind of some common themes. As I said, they're about 70 to 80% the same from deal to deal. So often they start with a letter of intent. It's not a mandatory document, but I will say probably 90% of the time when I'm working on a transaction, we have a letter of intent. And really that is a non-binding document except for certain provisions, and we'll get into that later, that lays out sort of here's what the buyer is willing to pay you if everything looks great, and here's our timeline. Here's some of the big terms that we think are important for the parties to be aware of. And here's the binding stuff. We're going to keep everybody's information confidential, and you seller aren't going to talk to anybody else about selling this business. So you're going to get confidentiality and exclusivity in a letter of intent. And those are going to be the really two enforceable terms. The rest of it is just, I'm interested in you, and here's what I think I'm willing to pay you, and we'll do our due diligence. And if everything looks good, we'll proceed to draft a purchase agreement. So a letter of intent is largely a non-enforceable document other than those terms about confidentiality and exclusivity. Once you get through that, ordinarily you move into due diligence, and that's going to look at financial data. It's going to look at clinical data, and we'll talk a little bit more about what due diligence is later on. And then you're going to draft purchase agreements, and those are almost 99.9% of the time drafted by the buyer. And the purchase agreement will include purchase price and terms, including any holdback escrows or sort of post-closing what we call earnouts. It will include a section on what we call representations and warranties. It will address what we call indemnifications and exceptions and limitations to indemnifications. And then there usually are some ancillary closing documents discussed in the purchase agreement. And then if everything looks great up to there and you get your purchase agreement in order, eventually you will move to closing, where the actual legal ownership of either the assets or the membership interest or stock of your organization gets transferred. Let's go to the next slide. All right, so before you draft and sign an LOI or a purchase agreement, I'll say it over and over, and I'm sure Heidi will too, find an attorney who knows what they're doing in healthcare transactions and talk to them. Federal and state law can often impact terms and timing in a healthcare transaction, and your counsel representing you, whether you're the buyer or the seller, can outline and help you understand and work through limitations in purchase price, financing, notice periods, and other key terms in the agreement. I often represent sellers. I do buyer side deals as well. And my job as a seller's attorney is to make sure you get the deal you negotiated, so that the words on paper match the conversations and the verbal discussions, and sometimes just the language in the letter of intent that you expect. And I will guarantee you there will always be something in a purchase agreement addressing some term you didn't think about. And so the point there then is, if you have an experienced healthcare attorney, they can help you understand, what do those terms mean? Are they industry standard and reasonable? And is there flexibility to negotiate something that is more equitable or works better for one side or the other? I'll just give you an example. Often I've seen this over and over again, people who are going into buying healthcare organizations that don't necessarily have experience in healthcare. Private equity does this a lot. They've been operating in some, software or whatever, and they decide they want to get into the healthcare business, and they go and they, with their business people, start proposing purchase deals, and they build in some term that a healthcare attorney would go, we really can't do it that way. For example, if a buyer is going to pay a seller over time, or there's going to be any kind of post-closing, what we call earnouts, the federal and state fraud and abuse laws can limit how either long that payout period can be, or the structure of that earnout and how it's determined. So again, can't stress enough, it's important for buyers and sellers to have good healthcare counsel. Let's go to the next slide. So there's a couple big laws that we worry about in healthcare. I'm sure everybody's heard of the Stark Law. It's a civil law that prohibits a physician from referring patients for designated health services to an entity with which the physician or his immediate family have a financial relationship, unless an exception applies. The good news is for anybody who is a hospice owner, you don't have to worry about Stark because hospice is not subject to the Stark law. It is not a designated health service. Home health, however, is. So Stark would apply if a seller, home health seller, is physician owned and that physician will ever refer a Medicare patient to the buyer HHA once it's sold. That's very unusual, I'll be honest with you, because there are such limited scenarios where a physician can even be an owner of a home health agency. The only time I usually see it is when that physician owner doesn't actually practice in the community where the home health agency is operating because there's such restrictions on physician ownership of home health, and it's primarily because of the Stark law. So I don't worry a lot about Stark most of the time unless I happen to run across a deal where a home health owner is a physician or has a physician owner somewhere in it. Let's go to the next slide. There are some exceptions under Stark that if we do find ourselves in a scenario where we have to worry about it, there's one for something called isolated transactions, and it has some specific requirements that a healthcare attorney who's evaluating your transaction can make sure you're operating within these. Payment has to be fixed in advance. It can't take into account the volume or value of referrals. It has to be commercially reasonable, even if there were never any referrals between the seller and the buyer. And there must be no other transactions between the parties for 6 months, except those that meet another exception. So compliance with something like this can become really critical to the structure of the deal. Again, Stark is not one of the laws we worry about a lot in home health and hospice transactions because it's just rare that it actually applies. Let's go to the next slide. We do, however, worry about the anti-kickback statute because it applies to everything. The anti-kickback statute is a criminal law that prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. It's, like I said, it's a criminal statute that carries significant financial penalties and can, and often, if there's a prosecution, does result in jail time. Transactions among parties who refer to each other are subject to the anti-kickback statute. And I know everybody's gears are turning. Well, if a seller is selling their business to a buyer, where is the referral happening? Well, I'll tell you, if the sellers either continue working for the buyer after closing or remain in the community and have some other business that could potentially generate referrals to the buyer after they take over, anti-kickback is an issue we have to think about. The biggest area where I see this is in earnouts. So one of the financial terms we see, not all the time, but sometimes, is buyers want to come in and they want to pay you a portion of the purchase price at closing, and then they want to pay you some additional money after closing if the organization meets certain targets. And those are almost always related to some financial target, whether it's revenue or EBITDA or whatever. That can become very problematic if the seller is going to continue on with the business. And there are ways to navigate this. In fact, I just did a deal in hospice not in Texas, in another state, where this was an issue. And we had to very carefully structure both the earnout and the job duties for the buyer who was going to stay on as an employee so that we didn't violate the anti-kickback statute. It just reinforces that you really do need experienced healthcare counsel when you're navigating these transactions and structuring them. Let's go to the next slide. There is a safe harbor under the anti-kickback statute for what they call sale of practices. It does not expressly apply to home health and hospice. It applies to sales of physician practices, but it is a kind of useful go-by for how we structure home health and hospice transactions in some situations, if we feel like there is risk under the anti-kickback statute. The thing to keep in mind, safe harbors are great. If you can meet every single element of a safe harbor, then you're immunized from prosecution under the anti-kickback statute. But if you fail to meet every element of a safe harbor, it doesn't mean that your particular deal is illegal. It just means the government's going to look at all the facts and circumstances to determine intent. And it's very common in what Heidi and I do. We spend a lot of time Walking that gray area, right? That fine line. If it's not 100% in compliance with a safe harbor, how close can we get? And, you know, with our knowledge of the interpretive guidance for these laws, the case law decisions for these laws, you know, what is the safe ground for all the parties to be on when it comes to structuring these kinds of deals? Let's go to the next slide. We already talked a little bit about this. If a deal doesn't fit a safe harbor or there is some regulatory risk associated, what can you do about that? Well, one thing, and often it's buyers that do this, is they're going to ask their lawyer for an advice letter that outlines the transaction terms, analyzes the risks, and documents what they're going to do to mitigate those risks. If fair market value is an issue in a transaction, a lot of times the parties will get an appraisal done so that they have an independent third party determining what fair market value for an asset is, for example. Those are often handy tools to have in your back pocket when you do something that is in that gray area. Let's go to the next slide. Heidi is going to take over in a minute. I'm going to cover letter of intent real quick, and I think she's going to step in here in a slide or two. But we talked a little bit about letters of intent a minute ago. As I said before, they're optional, but very common. It's a preliminary document that lays out key terms and sort of opens negotiation of really what I consider to be the more contentious terms in a transaction. Often it'll address issues like restrictive covenants. If the buyer is going to want to non-compete, generally we try to discuss that early on. It may discuss things like whether they're going to retain certain key employees of the seller or want to retain them as a condition of the deal. It'll talk about all the financial terms generally, purchase price, if there's going to be a holdback or an escrow, we talk about that. If there's going to be financing, it often talks about that. And any other what I would consider to be, big terms that parties need to be on the same page about before they get deeply into a transaction. As I said before, LOIs are generally non-binding except for non-disclosure and exclusivity provisions. And if you're going to do a letter of intent, it's worth doing it well. It's worth bringing these sort of big issues up for conversation and trying to resolve and make sure the parties are on the same page so that things go smoothly after that. I've said it already a million times, but either a buyer or seller consider seeking legal advice before you sign an LOI. I had one recently where we had a letter of intent that the buyer and seller had put together, or the buyer had put together and sent to the seller. And the reality was that the way it was structured, just from a regulatory perspective and a compliance perspective, it just didn't work. And they put some time and effort into it. And I think if there had been conversations before that letter of intent had ever been drafted, they would have ended up in a different place and it would have happened a little faster. That's not to say things can't get retooled. It's just, if you have that advice going into it before you settle on terms, and even before you make an offer as a buyer, it can help you navigate things a little more quickly, a little more cleanly. So let's go to the next slide. Due diligence. It's usually the first thing that happens after you sign a letter of intent. And the purpose of due diligence is for the buyer to learn about the seller's organization. And my advice to sellers is your job in due diligence is transparency. It's your job to tell the buyer everything they ask, everything they want to know. This is not the time to play games. It's not the time to hide anything. They need to go into this transaction with their eyes open. And if you don't tell the buyer things that end up being material, you're going to be on the hook for it as a seller. So buyers are warned, caveat emptor, and sellers are warned, be fully transparent. It's the only way the deal's going to get done and get done well. Both parties, but usually the buying party, conducts due diligence to ensure the business or ownership interests they're purchasing are what they think they are. And they're going to review things like financial statements, tax returns and liabilities, business operations, office locations, licenses, certifications, personnel matters, and every other aspect of the business. I will say due diligence looks a little bit different depending on the form of transaction you're doing. In an asset deal, it's going to look a little different than if you're doing an equity deal, The reason being is, in an asset deal, a buyer gets to pick and choose what they want. They're not taking the business itself, they're taking the assets of the business. In a equity deal, they're either buying stock or membership interest, and they're going to own your company at the end of the day. So they're going to get all the liabilities that exist within that company the minute they close that deal. So due diligence in an equity deal tends to be a little more intense than it is in an asset deal. And there are reasons that you do one versus the other, and Heidi will get into that a little bit more as we go on. So let's go to the next slide. And Heidi, I think I'll cover this, and then if you want to take over from there. One of the things we often recommend, especially for buyers, if we're representing buyers, is they do a mini claim audit. Sometimes this is done by an outside consultant. Sometimes it's done by legal counsel. Really just depends on your legal counsel's expertise and often, cost and timeline drive who does this. The reason this is important is if the buyer is taking assignment of your Medicare and Medicaid enrollments, then they're going to get successor liability associated with those enrollments. They're going to take all of the liabilities that come along with your Medicare and Medicaid provider agreements and keep them. And they'll write in a contractual provision that says, I'm taking assignment of it, but seller, you're going to be responsible for any liabilities that relate to pre-closing time periods. Nevertheless, Medicare and Medicaid still are going to come to the buyer first when they have an issue, regardless of when they think a liability arose. So claim audits and understanding the quality of the clinical documentation and the sorts of clinical issues and decision-making and processes that have been in place is really important for a buyer. Oftentimes we have to engage experts. Those might be clinical, those might be tax, they may be accounting, but oftentimes in due diligence, we find ourselves reaching out to experts in certain areas to help. It's a time to identify weaknesses in medical records and other documents that support claims that can often drive some internal changes. It can drive the form of the transaction. It can result in additional escrows or holdbacks if a buyer thinks that there's a really high risk of audit liability. It really varies a lot depending on the organization and the buyer and how they decide to do due diligence. Big problems identified in due diligence can result in purchase price adjustments. They can either drive the purchase price down, or they can result in a buyer asking for more money to be held back for longer. So if your purchase price was $1 million and they originally say proposed we will hold 10% of that money for a year, if they found a big issue in doing a clinical review and decided they had some audit risk, then they might say, listen, we're going to hold $200,000 for 2 years so that if there's a pre-closing liability, we have a way to be reimbursed for that, and there's a pool of money available. Sometimes really big issues kill deals. It's just the way it is. Usually, I will say that's not often something that happens. The only time I've seen it happen, and pardon the barking, but the only time I've seen that happen is I was working on a deal several years ago where we had a letter of intent, we were in due diligence, we were drafting purchase agreement, and the seller ended up the target of a really significant piece of litigation, and that killed the deal. So things like that happen. It's unusual, but it does happen. So I'm going to pass the baton to Heidi if you want to take over from there.
Sure. And just as a heads up, I am working from home today as well, and I have dogs. They are sleeping at the moment, but God forbid somebody walk by. So if that happens, I apologize in advance for dogs sounding off, but it happens. All right, as Jennifer said, there's a process and a step to everything. I wholeheartedly endorse everything that she said about the LOI and due diligence. You really want to spend the time that you need on the due diligence. And once you have completed due diligence, or while you're doing the due diligence, you're going to be working on the purchase agreement as well. And the purchase agreement is the definitive document for the transaction. Once you sign the purchase agreement, it becomes what controls what this transaction looks like. Your LOI basically ends and it vanishes into the dust. And if there's any litigation, they're going to look to the purchase agreement. So it is a binding document, and it's going to set out, again, the price, risk allocations, and anything else that is important in the transaction. Again, courts will look to this as the basis for all of either the buyer's or the seller's legal rights regarding closing, and payment structures, penalties, and liability exposure after the transaction has occurred. So you want to spend some time and effort on this, and you really want to have attorneys involved at this process. And if you've done your LOI well, many of the key aspects of the purchase agreement are just going to flow over from the LOI. But if you don't do an LOI, you again want to make sure this is very carefully done. And again, this has to be the reflection of what your intentions are regarding the purchase or sale of the particular business. Next slide, please. We have three types of transactions. One is an asset sale, the second is an equity sale, and the third is a merger. And Jennifer has already alluded to these different kinds of transactions. In an asset sale, the buyer is acquiring only certain identified assets, properties, and liabilities of the seller, but not the equity. And typically what happens here is there is a new owner or a new EIN after closing, or the purchasing entity just, again, acquires particular assets, and title and ownership of those assets move over to the purchasing entity. In an equity sale, the buyer is purchasing the seller's entity in the business as a whole, and therefore acquires all of the business lock, stock, and barrel, including all liabilities. So where you have this looking is you will have the same corporate entity and the same EIN after closing, but the shareholders or membership interests, if you have an LLC, in the entity will be what is changed. And in a merger, you have two companies coming together, and they form either an entirely new entity or one company merges into the other and ceases its existence. We don't see mergers too often. We usually see asset sales and equity sales, but mergers do happen. Next slide, please. So we have some unique features in healthcare transactions. So home health and hospice agencies very typically have few what we call hard assets. So it's not like you're a manufacturing company or entity where you would have machinery or inventory or something like that. Most of the value for these entities is going to be in the goodwill. And here in an asset sale, the buyer generally does take assignment of the Medicare and Medicaid billing numbers, but you don't want to take on any liabilities. So basically you're trying to, I hate to use the word, but kind of cherry pick what you are buying. This asset sale is common where the seller has some non-healthcare debts, or the buyer does not want the Medicare or Medicaid numbers, or the buyer is particularly risk averse. Very, very common. In a stock or membership interest sale, the legal entity, as I said, owning the agency does not itself change, only the shareholders or members do. And here, the buyer does accept assignment of all the Medicare and Medicaid buyer provider agreements, along with any other liabilities. So again, you're purchasing this company lock, stock, and barrel. If there's something that comes down in the pike in the future as a liability, this is something that the purchasing company will ultimately be liable for. And again, in a merger, the successor liability is going to depend on the structure of the transaction. So we're not going to get into that in a whole lot of detail. Next slide, please. When you're looking at the purchase price, typically the buyers and sellers, of course, have competing interests. The seller wants all of the purchase price at closing, whereas the buyers really don't want to do that because they don't want to have any concerns about liabilities coming down in the future. So typically what happens is that buyers want to pay a portion of the purchase price at closing, and as Jennifer said, then hold something back to cover potential liabilities for some specified period of time in an escrow account. And again, the how this works is going to be dependent to some extent on the due diligence that is done. So holdbacks can range anywhere from 10 to more than 25% of the total purchase price, depending on what the risks are. I saw one transaction that had 30% of the purchase price being held because the purchaser really wanted to buy the agency, but there were also some significant issues that cropped up in the claims audit. And so they negotiated a 30% holdback. And again, the holdback periods can vary anywhere from 6 to 36 months, depending on the risks that are identified during the due diligence process. If you are going to have any kind of a holdback, you do want to have a formal escrow account or agreement to protect both the seller and the buyer. And this ensures that the payment of the holdback will be paid once either the time period expires and there are no claims or other conditions are met in the escrow agreement. Now, there usually is a fee to have a formal escrow account and agreement, but consider it insurance money. It is well spent. And it protects the buyer as well, not just the seller, because it assures that the buyer has money available if any unanticipated liability crops up, or if a liability crops up that is foreseeable, such as a claims audit and overpayment request. Some owners are willing to self-finance, and they allow the buyer to pay a down payment with structured payments over time. If you're going to do that, you want to have a secured promissory note, again, to make sure that the sellers get paid. And what we often see is purchase price adjustments at closing. So for example, if there are outstanding liabilities, something as simple as utilities or rent payments, the purchaser may offer to pay those debts. They may pay the transaction costs of the seller. You might also want to leave a pot of money to provide working capital for the buyer so that they don't have to, pay a purchase price and then turn around and invest tens of thousands of dollars immediately in paying liabilities like utilities and payroll and so on. So we see a number of adjustments, and there can also be adjustments for the amount of outstanding AR or something like that. Next slide, please. Another important section in the purchase agreement is representations or warranties, or as we attorneys call them, reps and warranties. And basically, they are statements that legally confirm either the truth or the falsity of certain conditions, or well, actually more that they're true. And the disclosure schedules will usually identify specific exceptions or facts tied to reps and warranties. So for example, a common rep and warranty in every transaction is that the seller is a validly constituted business in the state of Texas and is in good standing, and that the person executing the documents has the full authority to execute those documents. So you might have something like, all the taxes are current and paid. All of those kinds of things go into reps and warranties. And the specific reps and warranties, again, can be negotiated as you go through the transaction. A material inaccuracy in your reps and warranties can be grounds for the buyer to sue or to seek indemnification. So again, as I said, you want to make sure that your reps and warranties are very carefully considered and drafted. And again, as we have common examples, a statement that the financial reports are accurate and complete, no litigation or audits are pending, and that the business has complied with all applicable laws. Next slide. Because healthcare is a unique situation, as Jennifer mentioned earlier, we also have some unique reps and warranties that only apply in a healthcare setting. So examples of these are that the seller has all licenses, certifications, and contracts necessary to operate and those licenses, etc., are current and in good standing. We put in a rep that the seller is enrolled in Medicare or Medicaid, if that is appropriate, and those enrollments are active. If there is licensure, we also want to make sure that the seller or the seller's owners are not subject to disciplinary or corrective actions or appeals. You also want to have a rep that the seller has been conducting exclusion screening, has records of it, and that no employees, contractors, vendors, or owners are excluded. I won't go into exclusion screening here, but this is something that can definitely rear its head down on the road, and you want to make sure you have this covered, or have some indemnity in an escrow, indemnity language, or cover escrow if there's any kind of question about this. Another rep and warranty is that there are no claims, enforcement, or other actions or administrative proceedings, audits, or investigations pending against the seller, the selling entity, or the seller's owners. And in home health and hospice deals, the seller has to make a rep and warranty addressing the 36-month rules. And again, you're going to be stating, has there been a change in majority ownership in the last 36 months? Hopefully the answer is no, and if not, that is something that then needs to be discussed and made part of the transaction, and there are ways to do that, which I'm not going to get into right now. Next slide, please. Indemnification. This is basically protection for the buyer and the seller. The seller agrees to compensate and hold harmless the buyer for any problems that may arise in the business as a result of the seller's actions, breaches of reps and warranties, or claims by third parties that relate to periods of time that are prior to the sale. Indemnification can also protect the seller. Again, if you find out that the seller, for example, is not authorized to conduct business, or the seller, declares bankruptcy before they finish paying off your promissory note, those are some of the kinds of things that we might want to consider in an indemnification. And again, to make sure that your indemnification actually has teeth and the wherewithal behind it, what you should consider doing is consider escrowing a portion of the purchase price to cover these indemnification obligations for a defined period. And again, the exact amount and the exact time is going to depend on what you find as through your due diligence. Next slide, please. So qualifications and exceptions are something that modify to some extent the reps and warranties, and it's anything that can limit a party's liability. So for example, you can have a cap or a minimum amount on indemnification, or a disclaimer or revision of certain warranties. What we often have is a materiality qualification that says that you won't seek indemnification unless the issue has a material effect on the business. You also may want to have time limits on indemnification, and here you need to consider statute of limitations. Remember, we have statutes of limitations at both the state level and at the federal level, and so your statutes and time limits may vary. And because the qualifications and exceptions really reflect sort of what you find during your due diligence and as a result of the negotiations, they can end up really varying from transaction to transaction because they are so fact specific. So another thing you need to think about as you are working through your purchase agreement. Next step. Next slide, please. So once you have negotiated your purchase agreement, you go to closing. And closing is when you finalize the transaction. So sometimes closing is the same day that the purchase agreement is signed, or sometimes you sign the purchase agreement and then you actually go to closing later. And this is the model basically if you're purchasing a house, for example. You sign the purchase agreement for purchasing a house, and then you go to closing some period of time later. We find delayed closing to be the case, particularly if you need third-party consents, such as regulatory or contract consents, or if there is financing involved where the buyer needs to obtain a loan from a lender. One of the things that we always put in a purchase agreement is a conditions to closing, and these are conditions that must be met before you actually go to closing. And of course, failing to meet one of these conditions is a reason not to go to closing. So examples would be that the buyer can't qualify for a license, that certain consents haven't been obtained, or that financing falls through, very common ones. Next slide, please. So at closing, the parties review all the relevant documents, and hopefully you've agreed to any necessary additions or revisions before actually doing this at closing. And then you sign the documents and you officially transfer ownership of the assets or the equity interest in the business. And concurrent with the signatures of the documents or immediately thereafter, the purchaser is going to transfer the funds to the seller, and will also deposit any escrow of funds with the escrow agent. And by the way, an escrow agreement, when you have escrow, an escrow agreement is typically part of the packet of documents that you will close at closing. And mind you, there may be many, many documents as part of the closing. The exact number and kinds of documents are going to depend on the kind of transaction and, again, what may have cropped up during due diligence. Next slide, please. So a lot of people think that once you go to closing and the money is transferred, that's it. But the truth is that the relationship with the parties rarely ends at closing or after closing. For example, many buyers want some sort of transition period where the seller stays on for a period of time. And they do this to assist in retaining employees and patients and to training up the purchaser on the specific workflows and patterns of practice that the buyer has. The goal of the seller in this period is to minimize its exposure to liability from claims for the seller. So it really does behoove the seller to participate in here and make sure that the buyer is on a good footing to run the business post-closing. Now, the buyer, conversely, is now running the business and has all of the responsibilities involved. And if issues arise where the seller should have disclosed something or for which the seller is responsible, the buyer may seek a legal remedy. Sometimes you have some kind of an agreement where you might negotiate or go to arbitration, but hopefully you can resolve a lot of these things. And again, many transactions have deferred payments. There are different kinds and many different kinds, and so we won't go into those in detail. But when you have those kinds of deferred payments, such as, for example, an earnout, the buyer and seller are going to be relying on each other to comply with those obligations that trigger the deferred payments and with reporting on that. So things to think about. Next slide, please. Many transactions do include restrictive covenants. Some are to protect the buyer, such as a non-compete and a non-solicitation covenant. And a non-solicitation basically says you're not going to poach employees. And others will protect the seller and their reputation. So there are going to be covenants concerning the employees. They can't disparage the sellers, for example. There's going to be covenants relating to terminations, pay, or severance. And these restrictive covenants are common subjects of dispute between the parties post-closing. And for that reason, you really want to have any of these covenants reviewed by an attorney. Non-competition agreements, for example, are now really the subject of a lot of negotiation, especially since the FTC came out with a rule that prohibits many kinds of non-competition agreements, not all, but many kinds. And so you want to make sure that your non-compete agreements are limited appropriately in their scope by geography, time, and practice area. And you're really going to need some assistance on that front. Next slide, please. Again, you may have some purchase price adjustments based on valuations or sharing of accounts that existed as of the closing date and that have not yet been paid. So for those reasons, you need to make sure that your purchase agreement does define how AR is going to be split, and you need to specify that with specificity. I know that's a sort of lots of words there that are the same word. This is really a big source of a lot of conflict post-closing, but you can avoid that if you discuss it thoroughly and do that in advance, and you include the language in the purchase agreement. And again, this really, again, points to the need to do your due diligence. Buyers also often want purchase price adjustments post-closing, and because if you have a transition period and the seller is working to do the transition, you want to discourage the sellers from basically stepping back and letting the business fall apart during the transaction negotiations or while waiting for closing. So there are some covenants in there. And of course, don't forget to file your Medicare or Medicaid change of information or change of ownership applications timely. Remember, you have 30 days after closing to do this, but sometimes that vanishes because people are so busy doing everything else. Next slide, please. And we're coming close to wrapping up here. So we do have some special issues for home health and hospice. As Jennifer mentioned, we have the 36-month rule, so make sure you're aware of this limitation. Hospices with an asset sale or 100% equity sale can now be subject to enhanced oversight by CMS, which does include prepayment reviews for anywhere from 30 days to a year post-closing. If you have a 36-month period that you have to wait out, often the buyer will want to manage the agency during this period or while waiting for closing to happen. You can still have the buyer manage the agency by drafting a management agreement, and you build it into the deal. And again, this needs to be done very carefully because, as Jennifer said, we want to make sure that we don't trigger any other laws like the anti-kickback statute. You're going to want to review the contract assignments of the payer contracts and their notice provisions. This is a thing to think about. Does a sale require a prior notice to the payer in order to transfer the contract? Some contracts do, some contracts don't. You have to know what staff you will be retaining, because the staff are not really, or I'm sorry, the patients. The patients don't know who the management is. They really only have contact with the staff. And if your staff leave, your patients might leave as well. So know which staff you're going to retain. If you are accredited, don't forget to notify your accrediting body. And as part of the due diligence, the buyers should review the compliance plan, policies, and procedures, and again, any audits that may have occurred, whether they be internal or external. And finally, consider any cost-saving strategies that might be realized in the transaction. So for example, are there redundancies that could be moved? Can you streamline any of the technical or administrative systems? Is there an improved outreach or increased marketing efforts? You want to make sure that this transaction is a good deal for you if you are the purchaser especially. Next slide, please. So to wrap up, transactions are a complex and often lengthy process. I actually just earlier in the year closed on a transaction that took us probably 2.5 years to close. Won't go into the reasons why, but can be, as I said, very lengthy and complex. They're very rewarding if you've done your research and you do your documentation correctly. While you're in this transaction period, be it negotiation or waiting for closing to come, you always do want to make sure that the target business does continue to operate in its customary manner. again, that's a huge deal and one of the reps and warranties in there. You want to be aware of fraud and abuse issues, as Jennifer said, not so much with Stark, but really you do want to consider the anti-kickback statute. And you really want to engage experienced professionals to handle this transaction, and that's including lawyers, appraisers, and accountants. We have been in transactions where, with all due respect, the attorney on the other side is their wife's cousin's divorce lawyer, and those individuals really don't have a good handle on some of the nuances that are involved in healthcare. So just make sure you go with experienced professionals. And you also need to be aware of the long-term risk allocation issues that go on long after closing. Again, these are going to be some of in your reps and warranties. They may be reflected in your indemnification provisions, and they may be reflected in your escrow provisions. But again, just because you close a sale doesn't mean you no longer have a relationship with the other party. Next slide. That is our presentation. Gio, do we have any questions? I can stick around for a few minutes. Jennifer, I don't know if you're able to.
I'm here.
Okay.
Yeah, we don't have any questions, as I can see for right now. So I'm just going to close out.
Sounds good.
Okay. Thank you so much to our presenters, Heidi and Jennifer, for that information. And thank you to our attendees for joining us today. Like I said before, I will be sending a copy of the PowerPoint slides tomorrow. And if you have any further questions, please reach out to Heidi and Jennifer, as you can see on the screen. And have a great Wednesday.
Thank you all. Bye-bye.